Thank you, Mr. Chairman.
Yes. I understand that it would be better that I deal with an application for a postponement
That is so,
in
Mr.
regard to a witness who was scheduled to testify today
That is correct.
and to cross-examine somebody.
Mr. McBride and
When we then continue with Mr. Nhleko, there is no interruption until we finish within the 2 hours that I hope we will finish within.
thank
So, okay, I think let's deal with that application first. Remembering what happened on Monday, it does appear that this is a situation where both Mr. McBride, who was to be cross-examined, is applying for a postponement, as well as Advocate
Pretorius.
JP Pretorius SC is also applying for a postponement.
That is correct.
Okay, let's deal with that first. Do you want to place your position as the
Thank you,
Commission's legal team on record?
Thank you, Mr. Chairman. Mr. Chairman, I was given an indication by my learned friend, Mr. Matabedi, who appears on behalf of Advocate Pretorius, that it was his instruction to bring an application for a postponement. He indicated to me that there were certain issues that he felt ought to be addressed in the affidavit and had not been addressed in the affidavit of his client. I had considered the affidavit prior to that, and it was also my view that there was much that had not been addressed in the affidavit. And if it had been addressed, I felt that it would have curtailed the proceedings to a significant extent. In the context of his indication to me, I did indicate to him that if I could, if certain demands on our side could be met, I would not oppose the application for a postponement because I believe that it may well curtail the issues. He acceded to the demands, and in that context, I'm now placed on record that as the evidence leaders, we do not oppose the application.
And obviously, in the light of that, you would adopt a similar approach to opposition to Mr. McBride's own application for a postponement, and given what happened on Monday.
Indeed, we've already placed ourselves on record as far as that's concerned, and he was granted a postponement in relation to Monday, and we hold the same view in relation to today.
Yes. No, that's fine.
As far as General Boyson is concerned, he has indicated that he's on standby. We had anticipated that if the evidence was led and he was going to be subjected to cross-examination, we would phone him once the time arrived, or more or less once the time arrived.
Yes. Okay,
Thank you, Mr. Chairman.
That's fine. I think counsel for Mr. McBride must also come and confirm that she applies for a postponement in regard to Mr. McBride.
Thank you, Mr. Chairman.
Good morning, Mr. Chair.
Good morning.
I, for the record again, place myself on record. My name is Catherine Harding, and I appear on behalf of Mr. McBride. Mr. Chair, I'm instructed to appear as I did on Monday in order to request an adjournment of the cross-examination of Mr. McBride by Advocate Pretorius's team, as was granted on Monday in respect of the cross-examination by Mr. Nhleko's legal team. I do so, as I did on Monday, on the basis of the affidavit that was filed with the Commission on the 26th. It appears at page 3650 of your bundle, Mr. Chair, bundle Y8H. The affidavit, I believe, has been provided to Advocate Pretorius's legal team, and my instructing attorneys, Adams and Adams, addressed further correspondence to Advocate Pretorius's attorney yesterday, again attaching that affidavit and confirming that I, on behalf of Mr. McBride, would be requesting an adjournment today, as was granted on Monday. The basis of the request, as you will recall, Mr. Chair, is to afford Mr. McBride and his legal team sufficient opportunity to prepare for the cross-examination by Advocate Pretorius's legal team.
Yes.
And the detailed reasons for that request are set out in that affidavit.
Yeah.
Mr. Chair, if you would like me to take you through those reasons again,
No,
I'm
it's
prepared
not
to do so.
necessary. Yeah.
On that basis, Mr. Chair, I refer you simply to paragraphs 20 and 21 of that affidavit in addition, in which Mr. McBride acknowledges the inevitable inconvenience and apologizes to all parties involved, and sets out how he tried to ameliorate that inconvenience as much as possible. I wish to re-emphasize Mr. McBride's commitment to the process and to appearing to be cross-examination, subject to having had sufficient opportunity to prepare for that cross-examination. Mr. Chair, I therefore request an adjournment of his cross-examination by Advocate Pretorius's legal team.
Okay. No, thank you.
Thank you, Mr.
Thank
Chair.
you. And then counsel for Mr. Pretorius.
Morning, Chairperson.
Good morning.
Matibedi TF, together with Advocate Madlanga and Ramaimela, we appear on behalf of Advocate Pretorius SC.
Thank you.
Chairperson, on the 27th of this month, a substantive application for the relief as more fully set out in the notice of motion was launched and delivered, and acknowledged thereof was given to us, my Lord. Chairperson, the reason why we are seeking a postponement is due to a number of reasons. Our client was served with a notice indicating that the cross-examination of Mr. McBride and General Boysens will take place today. However, during the discussions that we had, it became apparent that the evidence of Mr. Kuba and Sisoko will also, play a role today. The challenge with that is that my Advocate Pretorius was not given a notice, the required notice, indicating that both Mr. Sisoko and Kuba were going to implicate him. Now, it's impossible in leading the evidence of Pretoria SC that we would not make reference to the evidence of both Mr. Kuba and Sisoko. And the quandrum that we find ourselves in is that once he refers to that evidence in his evidence in chief, then the evidence leaders are entitled to cross-examine him on the evidence that he tendered. Now, what is in best interest of Mr. Pretoria SC is to bring a substantive application for the condonation and for the leave to cross-examine both Mr. Kuba and Sisoko, as the evidence of both Mr. Kuba and Sisoko is interrelated with that of Mr. McBride. So it will serve or curtail the proceedings if that is done in a together. And the other aspect is the fact that Advocate Pretorius SC, he was given permission to cross-examine both Mr. McBride and General Boysens. But on a perusal of the initial application, it became apparent that he did not deal with a lot of issues that he was supposed to deal with. Now, that being the case, it is very important that we should supplement his affidavit, and by so doing, that will also curtail the proceedings. Otherwise, on the evidence before the commission, if one has to apply the principle relating to how evidence has to be weighed, we respectfully submit that he will be severely prejudiced. And the other aspect is that there's an understanding between the evidence leaders and the legal team of Advocate Pretorius SC that we will address issues which the evidence leaders requires of Advocate Pretorius SC to deal with. And by so doing, we submit, and we are of the reasonable view that the proceedings with regard to the evidence of Advocate Pretorius, the cross-examination of Mr. McBride, General Boysens, Mr. Kuba, and Sissoko will be, curtailed, which is in the best interest of the Commission, taking into account, that the Commission at this juncture, operates under serious time constraints and restrictions. Unless the chairperson would like to hear me on a specific aspect, that's the case for Advocate Pretorius SC.
No, thank you. No, I don't need to hear you on anything else. I understand I have been reluctant to grant postponements unless really it was necessary, and there were strong reasons of late, precisely because the Commission has a very limited lifespan left and we need to finish the work. But the reasons that have been advanced in regard to Mr. Pretorius, I understand, and in the end, the curtailment of proceedings is in the interest of the Commission. So it's quite important that when a witness comes and a cross-examiner comes to cross-examine, the issues be quite clear so that the proceedings can run smoothly. So I'm prepared to grant that postponement, and I'm prepared to grant the postponement requested by Mr. McBride as well. I just want to say, everybody, counsel for Mr. McBride will be hearing, and you will be hearing, that because of our determination to try and finish the work that we have to do in the Commission within the time that we have, we may have a situation soon where we require people to appear in what I call our evening sessions. That means that you might not be required to present yourself at 9 o'clock or 10 o'clock, but maybe at 4 o'clock. And when the witness who was giving evidence for the day is done, we start with somebody, maybe we need 2 hours or 3 hours, we do that, we are done. So we go up to 7 p.m. or something. So as I grant postponements, I just want people to understand that they might find that we are in that situation. Obviously, the ideal thing would be to deal with a witness who can finish his or her evidence that evening. But if they can't finish, we will have to find a way. It's just an attempt for us to find more time, because, and starting early in the mornings, we might quite often start at 9 instead of 10 now, and instead of finishing at 4, finish at 5 or even 6, because just in 5 days, if we add 2 hours by starting at 9 and finishing at 5, suddenly we have 10 extra hours a week, and that can be very helpful. So I'm just mentioning that so that people should not be surprised, not only you, but other people should not be surprised if they soon get notices which indicate that your evidence will start at 4. But otherwise, I'm happy to grant the applications for postponement, one by Mr. J.P. Pretorius SC and the other by Mr. McBride, 2 dates that are still to be determined. Obviously, whatever needs to be done urgently. I don't know whether between yourselves and the evidence leaders any time frames have been agreed, but they need to be done urgently. I don't think that the dates to which that you will be advised of are going to be within the next 3 weeks. I think they'll be beyond that. But the sooner everything is finalized in preparation, the better. But otherwise, both applications are granted, and the hearing of the evidence of Mr. J.P. Pretorius SC and his cross-examination of Mr. McBride and General Major General Boysen is adjourned to a date to be given, and Mr. McBride's evidence also, the hearing of his evidence is also adjourned to a date to be fixed.
Chairperson, we are indebted to yourself and also to the evidence leaders.
Thank you very much.
Thanks, Chairperson.
Okay, all right. Are you ready, Mr. Halley?
Thank you, Mr. Chair.
Mr. Ntlego?
Good morning, sir.
Good morning.
Yeah, good morning, sir.
The oath you took 2 days ago continues to apply. Let's continue.
Thank you, Mr. Chair.
I don't know whether I said this yesterday, but if I didn't say it, then I'm saying it now. I'm going to be much more stricter today with regard to the proceedings. So, Mr. Ntlego, those long stories, I will only allow them if I think, strictly speaking, they are relevant. So, you will be trying to answer questions as briefly as you can. And then, Mr. Halley, I know that from our discussion here at the hearing yesterday, you will also be looking at going to dealing with the real meat
Yes.
of the issues.
Thank you, Mr. Chair.
Thank you.
Just to finish off on two topics that arose during the course of yesterday, Mr. Ntlego.
Yeah, sir.
The one related to the deletion.
I'm sorry, Mr. Halley. Is that lamp working today, Mr. Ntlego?
No, it's actually not working, Honorable Chair, and I must also declare that I brought along Iswasho to assist me. But nevertheless, no, I'm fine. I think I'm able to cope with the light.
Yes.
Thanks.
Well, I wonder what's wrong with that lamp because it's supposed to be working. So maybe during the tea break they must look at it again. But Mr. Ntlego says he's declaring that he brought Isiwasho. No, I did say that he continues to throw in these isiZulu words. Yeah, well, I know what Isiwasho is. So.
Thank you, Mr. Chair.
Okay. Yes, let's continue.
Thank you, Mr. Chairman. Mr. Chair, if I could refer to what is LEA4.
I must just confess, I suspect that it's just pure water and not Isiwasho.
Pardon me, I didn't catch that, Mr. Chair.
No, I'm sorry. I'm saying I suspect that what he's saying is declaring as Isiwasho. I suspect it's just pure water. Maybe he's intimidating you, Mr. Halley, so that when you question him.
He's been trying since the first day, Mr. Chair.
You know, Isiwasho is, I think, kind of blessed water that would be blessed by church people, isn't it? Or do you get it from traditional healers as well?
Though you also do get it from the traditional leaders.
Traditional healers.
I think it should be understood as a traditional medicine concoction.
Oh,
Yes, I think it's why sure that's probably what it would be.
okay. Mr. Halley, continue.
Thanks.
Thank you, Mr. Chair. Mr. Chair, the document that I would like to refer to next is part of a bundle of documents which we've marked or agreed to be marked as Exhibit Y8D. It's the affidavit of Matthew Sissoko.
May I confirm,
It would be LEA4 bundle.
Why?
So the exhibit is Exhibit Y8,
Yeah, but the bundle,
and the bundle is LEA4.
LEA4. Okay. I just want to confirm, Mr. Halley, we know that Mr. Ntlego did not apply for leave to cross-examine Mr. Kuba, but I take it that Mr. Kuba's statement and his evidence forms part of what you notified him.
I believe he
you would
has
cover.
been notified.
Yeah, okay.
If there's
Okay.
any challenge to that, understood from the address right at the
Yes.
beginning, you might recall that there was an indication that there hadn't been proper notice.
Yeah,
that had
okay.
been
No, I
given.
just want to make sure that we are on the same page as to the scope of the evidence.
Yes, indeed, Chair. As I pointed out, that he was not given the notice,
Yes,
but the affidavit of Sissoko and Kuba
Yeah.
came to his attention later, long after they've testified.
Yes,
But
yes.
he's aware of
He's
those
ready to
affidavits,
deal with them.
And remember what I said in my opening statement.
Yes.
That nothing really turns on the affidavit of
Yes.
Kuba and Sissoko.
Yeah.
And we said that we're not even going to waste our time to cross-examine them.
yes, no, I remember, yeah.
That's right.
Okay.
Thank you, Mr. Chair. Now, during the course of your testimony yesterday, you were speaking about the laws that were applicable to the processes within IPID and how IPID reports have to be finalized. Specifically, you were making the point, which is the point I wish to deal with for present purposes, that there was nothing in any law, to use your terminology, which required the executive director to sign any to sign off on any reports. Now we're speaking specifically about IPID reports. Do you recall that?
Oh, yes, I do.
Just 1 second. The heater stroke aircon. In the past few days when it was on, did you feel that it was warming up? If I say it should be switched off, does that prejudice anybody? I'll have it kept on if it does warm up, but if it doesn't, I'm
Speaking
not
for
sure.
myself, Mr. Chair,
It makes some difference.
when it goes off, well, it does make a difference.
Eh?
When it goes off, it becomes incredibly cold. I know that Mr. Ntlego
Oh,
has
is that
complained.
so? Okay.
But I would be happy if it
No.
gets switched off, if it's interfering with the ability to hear.
No, I think if both of you try to speak closer to the mic,
Absolutely,
that
Mr.
might be
Chair.
fine, yeah. Okay,
Thank you, Mr. Chair.
okay.
Now, just as far as the different legislation that governs the reporting duty of IPID is concerned, that of course is to be found in three different pieces or three different instruments. The one is the IPID Act, the other one is the IPID regulations, and the third is the standard operating procedures. Are you aware of that, sir?
Yes, I'm aware, sir.
Now, I'd like you to turn with me, if you will, to page, the bundle that I've referred you to a moment ago, that's Y8D, Exhibit Y8D, and you'll find that in bundle LEA4. And I'd like you to turn specifically to page 1542 of that bundle.
I'm sorry. Do you say that is in bundle LEA4?
4. That is correct, Mr. Chair.
Well, this one that I have here is LEA1. That's the one that was handed up a few minutes ago.
What it did read in the past was Y8D on the spine, but it ought to have been corrected to LEA4 in accordance with the directives that you gave us.
My one on the spine, this one is written bundle LEA1.
No, that's not the correct one.
That's not the
Should be
one.
LEA4.
That's oh, okay, no, I'm sorry. I think I've got it here. The one written, well, it's written Exhibit Y8D.
That is correct, Mr. Chair.
But it should be written bundle
LEA4.
LEA4.
That is correct.
Yeah, will your team please make sure that my bundles are written exactly what they should be written so
Thank
that
you, Mr. Chair.
there is no, so that there is no confusion. Okay, what page?
Thank you, Mr. Chair. If we can look at two different, the first page is at page 1542.
Yes.
Thank you, Mr. Chair. So if you would turn with me, Mr. Nhleko, to page 1547. But to place this in context, Mr. Chair, page 1542 indicates this to be the Independent Police Investigative Directorate Standard Operating Procedures, and the effective date is the 1st of April of 2013. You see that, Mr. Nhleko? That's on page 1542.
Yes, I think you asked me to page to 1547, and I'm at 1547.
Okay. The particular document, if you would turn with me to page 1575, you'll see there at the close to the bottom of the page that it's signed by Ms. K. Mbeki, who was identified as the acting executive director on the 1st of April of 2013.
That's correct.
Now, we know that Ms. Mbeki is, of course, was the acting executive director that has been mentioned here previously, before Mr. McBride became the executive director on the 3rd of March of 2014. Is that correct?
Yeah, no, that's correct.
Now, I'd like you to turn with me to page 1547. There's a definition there, the third definition that appears on that page, the definition of caseworker. Got it?
Yes.
And a caseworker is defined to mean any official who handles cases and includes a data capturer, a CMS clerk, an investigator, a senior investigator, principal investigator, an assistant director in investigation, a deputy director investigations, and director of investigations. that correct?
Yes, I see what it reads.
Now, if you turn with me then to page 1572,
Yes.
7.10, or paragraph 7.10, contains a table, and that table identifies the procedures for the completion and the closing of files and dockets. You see that?
I see that.
Now, under there, it sets out the procedure. Firstly, if you look at immediately under the heading procedure, there's an indication of what is contemplated insofar as the completion of files are concerned. And if you go down in the left column, you'll see items 1 all the way up to 5. And then beneath that, you'll see that there's a separate section which deals with the closing of files, and that is itemized as 6 to 10. You see that?
Yes, I see that.
Could you read item 1 under completion of file?
The caseworker initiates completion of a file through the supervisor after completing a case investigation report.
And could you read item 2, which deals with the obligations of the supervisor?
The supervisor reviews and assures directives and quality assures directives and reports and recommends completion to DI/PH.
And then can we look at what the obligations of the DI/PH are? And I'll take you through the definitions of those in a moment. Item 3, in other words.
Yeah, I see that.
What are the obligations of the DI/PH?
Approves, disapproves completion, and the completion register is utilized.
Now, to take you back to page 1552, we will find, just go back slightly. To 1548 for the definition of a DI. If you look roughly 4 items from the bottom, the director investigations means a person appointed as a head of investigations at provincial level. You see that?
Right.
And if you turn with me to page 1550, you'll see that the definition of a PH is a provincial head, which means an IPAD official appointed to head a provincial office.
I'm sorry, did you say that is at page 1550?
That is correct, Mr. Chair. So 3 items from the bottom.
Okay, now I see, okay. Yes.
And just to round off the definition section, if you would turn with me to page 1551. It says that a supervisor means any person who supervises a caseworker of any level. So a supervisor is not defined with reference to a job title, but rather with reference to a person who supervises a caseworker. You see that?
Yeah, no, I hear you. I'm following, Chair.
So just to complete, getting back to paragraph 7.10, It's the caseworker who has to initiate the completion of a file, and he or she would do so through the supervisor, item 1 that is, after completing a case investigation report. So, in other words, a case investigation report has to be completed, and that is the process of initiation of the completion of a file.
Right.
Correct? Then the next step after that is for the supervisor to review and quality assure a directive or report, and then to recommend completion to the DI/PH.
Right.
Now, you've worked in government for a long time, and you would be familiar with how one makes a recommendation, would you not, sir?
Yes, I would be.
And where you wish to make a recommendation, you would complete either a report, in this case a report, or it might be a memorandum, or it might be some other document in which you would have the words recommended, not recommended, and if you recommend, you would encircle the word recommend, or you would delete the word not recommended, correct?
That's correct.
And you would then append your signature, correct?
That's correct.
And then when you get to...
I'm sorry, Mr. Halley. I'm not sure that is the only way in which
I'm
to
not
make
sure that-
recommendations in government.
I'm not sure that it is. I'm not suggesting for a second that it's the only way. But I'm
It's
certainly
just,
suggesting
that the question, I think, was, as I understood you, was that he worked in government for a long time. He knows how recommendations are made in government. That's how I understood you.
Yes.
And then you went on to say how they are made. I know that he answered in a certain way, but that suggested to me that you are suggesting that if it's made differently, that might not be how recommendations are made in government. And I was just saying, I'm not sure that there is no other way of making recommendations within government other than that one.
Thank you, Mr. Chair. Well, we know that the method that we've described now is a method that is used within government. Are you aware of other methods that might be used to convey your indication as an official that you accept a recommendation? Sorry, let me rephrase that. That you are in fact making a recommendation.
No, I'm not necessarily aware of any other except the submission route, as it is called.
And of course, the appending of your signature in the case of those instances that you're aware of.
Right.
The appending of your signature is a very important aspect to convey your acknowledgement that you've made the recommendation.
Okay.
And then it's got to go through to a third level.
I'm sorry, Mr. Ntlego, do raise your voice so that I can hear your answers.
Oh, yeah, no. I keep on agreeing with Mr. Ali,
okay,
Chair, yeah.
okay.
So.
No, that's fine. It's just that you are competing with the noise of the heater, but it's okay. Just
Okay.
Yeah.
No, I'll try my best, Chair. Thanks very much.
okay.
Thank you, Mr. Chair. And then item 3 says that the DI/PH approves/disapproves completion, and the completion register is utilized. And it's got some code over there. We didn't worry about the code. But ultimately, it must be for the DI/PH to approve/disapprove completion and the completion register. So in other words, there's 3 levels before a report is ultimately approved. Would that be correct?
Yeah, no, I hear you.
Now, what we know in the case in this matter, we do know that, and we've debated it for some time over here, we do know that insofar as Mr. Kube is concerned, his particular report, being the report of the 22nd of January, was was signed only by him. Is that correct?
Yes.
Now, picking up on another topic that we dealt with yesterday.
Before you go to another topic, Mr. Harley, and you may have covered this angle, but I just want to make sure. I see, Mr. Nhleko, that Workmen's in their report to you also quoted the Regulation 5.1 of the regulations under the IPIT Act.
Right.
And I don't know if they quoted the whole sub-regulation 1 here or not, because where they start, they don't start with a capital letter, they start with a small letter. But they quote, after collecting all evidence, statements and technical or expert reports, if applicable, submit a report on the investigation of the offense to the executive director or the relevant provincial head, as the case may be, containing recommendations regarding further action, which may include disciplinary measures to be taken against a member of the South African Police Service or the municipal police service, or criminal prosecution of such member. I think I saw it might be a full Regulation 5, where the suggestion or what appears to be the position is that a report must be approved by the executive director. Is that something that you recall as having been the position? I know that you said yesterday there is no law that says a report must be signed by the executive director of IPED, but I seem to think that I saw something saying the regulations require the executive director to approve, but here it says the report must be, after all evidence has been collected and statements and expert reports, if applicable, must be submitted to the executive director or the relevant provincial head, as the case may be, containing recommendations. And maybe that might mean it. This particular part doesn't seem to say so what is quoted here, but it may be that the purpose of submitting is that he or she should approve. I don't know, what's your recollection about whether there was a requirement that the executive director should approve, whether he must sign or not sign, but he should approve the report? Do you have any recollection of what?
Just two things, Chair. I think the first one is that I think when Mr. July appears, we'll probably clarify that issue. And the reference to that particular section of the regulations. There are two processes here that should also somehow we should try and understand. The first one, the applicability of your standard operating procedures. It's more to do with internal controls, okay? Now, and the regulation, no, not the regulation, the standard operating procedure, as quoted by Mr. Harley, for an example, places an emphasis on quality assurance. Precisely because if you're the executive director, you are a supervisor, okay? So you will essentially need to satisfy yourself that the work that they would have done is complete, right? Now, that's an internal process matter within an institution. But signing off, I could, for an example, maybe let me try and make a practical example. Suppose the Honorable Chair is an investigator and reports to me. I would have to satisfy myself that indeed this report is okay, it's fine, okay? Whatever, issues of standard that I would have to look into that governs the manner in which you constituted or constructed your report and so on. Now, essentially, I would have to then say to you, it's fine, you can now refer this report to the NPA or whatever authority, okay? So that's the standard operating procedure. Now, the issue I was raising is that the standard operating procedure should not be equated to law that says it's compulsory for an executive director to sign off an investigation report.
Yeah, no, I understand.
So that's a distinction I was
Yeah,
drawing.
I understand that, but must I take your response to be that it was within your understanding at the relevant time that in terms of internal procedures within IPED, the executive director would have been required to have seen the report for purposes of quality assurance? That would have been your understanding?
That would have been, yes.
Yeah, okay, all right.
Thank you, Mr. Chief. If I can,
I'm sorry, but are you saying, as far as the regulations are concerned, you don't, or you do have a recollection that your understanding was that even the regulations required the approval of the director? Or you saying, I don't remember, I don't know whether the regulations say anything?
It might require for me to have a relook at it, but I really do not recall a situation where regulations, because the regulations, by the way,
yes,
they are not standalone.
internal.
Yes, no, they're not standalone. They fall off from legislation.
Yeah.
Yes.
Okay, no, that's fine.
Thanks,
thank you,
Chair.
sir. And although we're not really dealing with this issue, but just to round off the issue on page 1572, you'll see there that 1572 deals also with the closing of files. And without belaboring the point, it follows the same process as in relation to the completion of files, where the process of the closure of the file is initiated through the supervisor. Sorry, is initiated by the caseworker through the supervisor, and then it is escalated where the supervisor has to review and quality assure the report, and then has to make a recommendation to the DI/PH, and then ultimately the DI/PH must approve or disapprove the closure of the, and in the closed register is utilized. So there's essentially a three-tier system of initiating either the completion of a file or the closing of the file. Is that correct?
Yes, I hear you, sir.
If we can turn to, I'd like to turn to an additional issue, but before I do so, I just want to make it clear that, as I understand your evidence, you're not suggesting that internally there's no obligation to comply with the standard operating procedure. That's not your point, is it?
As the term stands, standard operating procedure is precisely because you need to comply and adhere to certain standards of functionality. That's why it's called standard operating procedures.
Thank you, sir. Now, insofar as the two reports, and I'm moving on to a separate topic now, but insofar as the two reports are concerned, you will recall that, once again, that there was the 22 January report, which had been signed by Mr. Kuber alone, and there was the 18 March report, which had been signed by Mr. Kuber, Mr. Sissoko, and of course by Mr. McBride. Now, when you approached or when you approached IPID, through your letter of the 24th of November of 2014, and asked him for the case docket in respect of the rendition matter. Mr. McBride responded by sending you the letter of the 26th of November, in which he provided you with the full case docket. Is that correct?
Yes, sir.
And pursuant to that, or rather in that document, he explained to you that the docket was, the original docket, was with the National Director of Public Prosecutions.
I'm listening, sir.
Well, if you've got no recollection, then I would have to draw your attention. Sorry, if you have no recollection, I would have to draw your attention to the document.
Okay.
So if you would just bear with me.
Somebody must just make sure each time there is a reference to a different file that the witness is given the file that is referred to, unless
Thank you, Mr.
he is
Chair.
unless he is happy to deal with the question without looking at it. But it's better if it's made available so that he can then elect whether he wants to have a look or not.
You could turn with me to Exhibit Y7, Mr. Nhleko.
Yes, Mr. Halley, you are right.
No, don't worry.
Somebody should long have stood up to take the file and give it
Thank
to
you,
the
Mr.
witness. Yeah.
No, it's all right, Chairperson. I'm remembering some few things about administration, so I've already located the Exhibit Y7 file, and I feel so educated by being able to do so. Thank you very much.
Yeah, okay. Yes, I must say that so far I think we are moving quite satisfactorily. So let's...
I don't think we should jinx it, Mr. Chair.
Let's stick to that lane. Yes. Thank you. Just confirm again, Mr. Halley,
This is Exhibit
for the
Y7.
record, which file? Exhibit
Y7. It's one of the
Exhibit
historic
Y7.
bundles.
Yeah.
It's the supplementary affidavit of Mr. Robert McBride.
Yes.
Now, if you would turn with me to page 144.
144.
That is correct, Mr. Chair.
Yes.
To place this in context, Mr. Nhleko, this is the letter that we referred to at least yesterday and the day before. It's the letter of Mr. McBride dated the 28th of November 2014, which is addressed to you as the Minister, and it's responding to your earlier letter of the 24th of November. Is that correct?
Yeah, that's correct, sir.
If you turn with me to page 144 under the heading Conclusion at the foot of that page, Mr. McBride says that in the second paragraph beneath that heading, the recommendation with the entire docket and evidential material was forwarded to the Office of the National Director of Public Prosecutions on the 14th of April of 2014. On the same day, a disciplinary recommendation was forwarded to the Office of the National Commissioner.
All right.
Did you ever follow up with the National Director of Public Prosecutions to confirm whether he did indeed have the original case docket with the recommendations?
A follow-up was made, and I think that will also become much more clearer as and when we get to the testimony that would be led by Mr. July, specifically in the construction of what is commonly referred to as the Waxman report. And it would also reveal the internal communication, even within the National Prosecuting Authority, in regard to this matter.
So would it be fair if, just to paraphrase or to try and understand your response, would it be fair to extract from that your response is that the investigation or the follow-up in relation to whether the docket was with the National Director of Public Prosecutions was in fact done by Worksman's?
It was through Waxman's investigation.
If you could turn
Chair,
with me
could I
to
just
exhibit...
declare that it's extremely cold? It's extremely cold, Chair. I'm sure this is, if you're in a mortuary, this is how it feels, I suspect.
Well, I can tell you that Mr. Halley told me on Monday, which was his first day of leading evidence here, that he complained of extreme cold. Now, I have been here for a few weeks now, hearing evidence, but I've had the benefit of some small heaters as well, so I might not be exactly in the same position. I think they are going to try and see what can be done. The question is whether that is making it colder, and maybe if it is, it may be that it might be less cold without it than with it.
Possibly.
The relevant person has gone out. I think they'll see what can be done. Please raise your concern again if after some time you don't feel any difference. There might not be much we can do other than switching it off and on, because it's a big venue, and therefore I think it takes time, but also I don't know how effective it is. But I have heard that sometimes people have felt at least some slight warmth. I haven't heard anybody saying it feels very warm here.
It's a question of the advantaged versus the disadvantaged.
I think we're all disadvantaged in the current environment, Mr. Chair.
Well, I see
There's
when
degrees
you
of disadvantage.
say, I think when you say advantaged, he looks at me.
Yes.
Maybe because of the heaters.
Yes,
But
exactly.
quite frankly, the one I have today, I also don't. And yesterday I had two, and I think one was not effective. Today I've got one. It doesn't feel any different from yesterday. Okay, let's continue, and hopefully something will be done. I've been told this venue, the building is old. Some of the infrastructure is not good, so some of the things that one would expect are not there, because it's an old building with an old infrastructure. But let's see I think probably you would have been well advised to put on a jersey as well. Mr. Halley, when he felt it was extremely cold on Monday, he also didn't have a jersey, but yesterday he had a jersey on as well. So I've been wearing a jersey since we started here. Okay, let's continue, and just do raise your concern again later on if we continue to feel extremely cold. Yes, Mr. Hall.
Thank you, Mr. Chair. Now, as regards the two reports, if I understood correctly from your testimony yesterday, you had received the first report, that's the 22 January report, signed, and you know that it had been obtained through your internal structures, but you don't know precisely by whom. If I understood your testimony, you said it landed on your desk, and you don't know who might have placed it there. Correct?
Yes, I'm listening, sir.
And the second report, which was dated the 18th of March of 2014, that was provided to you by Mr. McBride through the letter, or attached to the letter, together with the docket on the 26th of November of 2014. Is that correct?
Yes, I'm following, sir.
Now, when one considers the two reports, and it's a proposition I had put to you yesterday, but we didn't get around to fully ventilate it, but when one considers the two reports, the second report, there was no suggestion that the second report had passed itself off as the first report. The second report was a report dated dated 18 March 2014. It did not purport to pass itself off as a report dated the 22nd of January of 2014. Would that be fair to say?
Maybe let's try some simpler English. I don't know. Are you saying?
Shall I start one step at a time then? Firstly, let's look at the date.
No, I hear that part, but let me get this point correct. You are saying there is a 22nd January report, which has nothing to do with the 18th of March report. Is that
I'm not saying nothing to do. That's far too strong for what I'm conveying.
No, I'm talking about two distinct reports.
I'm saying that the 18 March report does not purport to be the 22 January report.
It couldn't be. It's dated the 18th of March. So it couldn't be the 22nd January report because it's dated the 18th of March. So that's why I was saying let's maybe try and separate the two.
Maybe let me ask this question, and I think it might go back to an issue we discussed yesterday. Is there any reason why the report of the 18th of March could not be taken as a replacement of the report of the 22nd of January?
I think, Honorable Chair, earlier on, during the days that I've been sitting in this freezing place, I briefly spoke to this issue.
Yes. But
I even referred to the question of what the convention is, even worldwide. If you produce another report that has got to annul another one, you state so.
Yeah.
You then say, look, this report annuls that one. So I'm withdrawing that one, replacing it with this one. Okay? So that's what practice and convention would have. It would also be interesting that with regards to exactly this specific issue, to get the attitude of the prosecutors in the NPA, because they spoke to this issue as well. They had a reaction to it in relation to the second report that they then received. So my clarification would be that if then that is the case, because I don't think we should be understood as saying you can't replace a report. But if you replace a report, state that you're replacing that report and it's replaced by this one, okay? And state your reasons as to why you think this is correct. You know, I'm just making an example. I wanted to leave it at that. Chair.
No,
Thanks.
I think what you have said is that does clarify to quite a large extent what I had in mind. I think probably what Mr. Halley also had in mind, but I'm looking at him, he's not nodding, so he might, but
He hardly ever does. He hardly ever does not.
well, I haven't seen him shake his head either, so. But let me make this proposition to you, that
Yes,
what
sir.
you have said, namely, that if you want to replace an earlier report with a later report, you would write or you'd make it clear that this later report replaces the earlier one. Now, you may or may not give reasons, you know, but obviously, if the person you are conveying this information to says why, you would have to say why. Okay. You want to say something before I move on? Yeah.
No, thanks, Chair.
Yeah.
But in that regard, I think when we try to clarify ourselves around this issue in the manner in which the Chair is doing, at the back of our minds, we should not forget, these are investigation reports, so they rely largely on what is contained in the docket
Yes.
and the statements therein.
Yes, yes.
So I would suppose, for instance, without speaking for the NPA or for prosecutors there, because I don't know how they work, regardless of the allegations that have now captured them, but the point is, certainly they would have to factor the why question when you come in with a second report that says, no, I'm nullifying the other one. So it would mean it will take them back, all of them, the investigating officer and the prosecutors, it will have to take them back to the constituting material, which in that case is referred to as the docket.
Yes, no, I understand that. I'm starting from the general before going to the specific.
Okay.
I'm suggesting to you that you may not need always to explain why you are replacing one report with another, an earlier report with a later report. But obviously, if the person you are giving the report asks the question why, you would have to explain, you know. But I'm imagining if one of my staff Okay.
Thank you, Mr. Chair.
I'm sorry if I was understood to mean we would resume at 11:15.
That's the impression I got. I thought it was incredibly generous.
No, I'm under the impression that I said, let's make it a tea break. So the adjournment would be a tea break and we resume at 11. But it's fine, let's continue now.
Thank you, Mr. Chair. Mr. Nsteko, before the adjournment, we were dealing with the question of the two reports and what it is that you would have expected a person to do if it was their intention to annul or to change a previous report. Now, you've indicated that one would have expected in the new report to indicate that you've changed in the old report. Do I understand correctly?
Yes, I think I must have said that.
Now, you're speaking in general terms. If I understood you correctly, you're saying, well, you don't know what the processes are within IPID, but if I understand you correctly, speaking generally, that is what you would have expected.
Look, if you say general terms, perhaps I would want to qualify that because, in government, there are no general terms. There are practices there and conventions and regulations and laws. Now, because if you say general terms, it's as if you are referring to any other form of a report, including a newspaper report. I mean, it can't be.
But maybe because we were discussing this point earlier on, and
Yes, yeah.
I think we had not finalized it when the electricity went off. Let me also come in. This is the proposition I wanted to put to you when the electricity was, supply was interrupted. Namely that even if, or let me put it this way, is the position not that even if the person who is supposed to give you a report on a certain matter, isn't the position that even if he doesn't or she doesn't say, I'm withdrawing the earlier report, if having given you a report earlier on a subject matter, he or she gives you a later report, and the later report deals with the same subject matter, unless there is something in the later report that suggests that the later report doesn't replace the earlier report, it would be reasonable to take it that the later report replaces the earlier report. So in other words, unless the later report says, or unless the person tells you, you have got to read both, you need both. If the later report deals with the same subject matter, it would be reasonable to take the later report as replacing the earlier report. Even if they didn't say anything, if you read both, you might say it can't be intended that they both stand at the same time. One of them falls.
I like the last part. One of them falls.
The falling part.
One of the falling part. I like that.
Okay.
I like that, Honorable Chair. But the point really is that, and I think I tried to clarify this point. Look, in this particular instance, for an example, Chair, a report does not produce the docket, but it is the docket that produces the report. So it works the other way around. Now, the docket is the basis that constitutes the essential body of the report, right?
The report will be based on the docket.
On the docket, yes,
not
exactly.
the other way around.
Exactly. And I think there are wonderful points that or propositions that you also put to me yesterday, which made me think in a way, because I think it was in the process of thinking that we needed to reflect on some of these things. But I'm then saying, even if we are not talking of an investigation report, because an investigation report is a very serious matter. It's a very serious report, because it bases itself on statements collected, the analysis of evidence and whatever else and so on, albeit at a prima facie level and so on. But I also do think that the question that the chair is posing is well actually suited for the National Prosecuting Authority to respond to, right? What was their understanding? And is it their understanding based on law that you could produce a second report, and if you want to, produce a third report if you want to, and your understanding should always be that because the report is the latest, it replaces the first, the second, and the third report. I'm just making an example. I think for me, I would also be very interested in that. But I'm further saying, Chair, that, convention has it. If you produce a report, you must then state that this report that you're now producing replaces the other report on the same subject matter that you must have filed at some point. And you must advance your reasons. I mean, here, because we're talking of matters that are related to law and criminal prosecution, you would have to state your reasons why you are now changing and filing a latest report of any sort. And they would have to be cogent kind of reasons, I should think. Now, and that's why I'm saying we should draw the distinction around this particular matter, but I'm also very interested to hear what the NPA itself understands by this, because there were particular reactions on the side of the prosecutors that were assigned to assist IPID in this particular investigation, in their reaction in relation to the second report.
No, I understand that part, but remember
Yes, Chair.
that, as I understood your evidence yesterday, the report is not just for the NPA, it's also for you as minister at the time, as I understood it, because you may have to make a decision with regard to disciplinary matters. So, is that correct? Is my understanding correct?
Look,
If they recommend disciplinary action, I understood you to say you would have to make those decisions in regard to disciplinary matters, but the NPA would have to make decisions in regard to
on
criminal
prosecutory matters, yes.
My understanding is correct.
Yes, sir.
Okay, so I'm saying while the NPA's understanding of this question I'm raising might also be important, but it's important also in regard to you because you were expected to make decisions in regard to disciplinary matters. And when this issue of whether the first report was final or not arises, so it arises in regard to both those who were supposed to make decisions on criminal matters and you who are supposed to make a decision on the disciplinary matters.
Right.
So your own understanding becomes important. And that is why I pose the question and I invite your own understanding what it was.
Yes,
Because
sir.
the proposition I'm putting is that even if the person giving the report doesn't say this one replaces the earlier one, as you have suggested, I'm saying to you what about the proposition that you may, when you read the two reports, see that they can't both be intended to operate and to be valid. Only one can. And in that case, I want to put the proposition that it would be reasonable to think you would say is the latest one that must be intended as the report. And therefore, in that case, it replaces the earlier one. They are not meant to be, you are not supposed to make a decision, to base your decisions on both, particularly when they have material differences. So my suggestion is that, my suggestion to you, Mr. Nhleko, is that if you give me a report today, and 5 days later, you give me another one, dated 5 days later, on the same subject matter, and you don't make a note for me to say I must ignore the first one, and you go away. If I read both and see that there are differences, even without asking you, it's reasonable for me to think that I must take the later one as intended to replace the first one. What do you say to that proposition?
The Honourable Chairperson, I hear you, but still disagree with you.
No, this is the opportunity to disagree with the chairperson.
I still disagree with you.
Because I want to understand your own
Yes.
approach and understanding how you approach the reports. So it's important for me to understand that.
I would say to you, Chair, look at it from an angle of a person who has an institutional responsibility. An institutional responsibility, and of course, in this definition, I'm deliberately excluding the NPA because I think you made a general point. So we're not talking about the specific in this regard. So, but let me also try and be general. So here you are, you're a manager, you're a supervisor, and your subordinate has filed a particular report, let's say some few weeks ago. And this subordinate says, this report, this is how it's final, and I've finalized it. Okay? But then the same subordinate comes back 3 weeks later with another report on the same subject matter and does not refer to the first report and says to you, here's a report. It's as if it's a new report. Okay? Firstly, that on its own, there's something wrong with that. Even that approach, completely wrong. But nevertheless, suppose I ignore that as a person who holds institutional responsibility, being a manager or supervisor of sorts. Now I've got to take a decision. The dilemma that you then have is that you have two reports before you. All of them valid. Valid in a sense that the first one filed 3 weeks ago has not been withdrawn, is still the same. Now you have a second one, which is not a continuation or supplementary report to the first one, because that's a different matter. If it's supplementary, it means continuation. So you now have a second one. Now, this second one does not talk to the first one, but the subject matter is the same. All you have are material facts that have been removed from the first one to constitute this one. The question is, in the execution of your duty, what do you do? Now, if you assume, if you make the assume as the chair implies, I can assure you of one thing. You would be introducing institutional instability and turmoil within that very same institution, because you are likely to then say, no, I assume that the second report is the valid one. And therefore, on the basis of which I'm making these following decisions. So you make your decisions, but your decisions are wrong because they could then also be challenged by some of the issues arising out of the first report. So your decision-making shall always be contested, and that's why you need to have absolute clarity around these particular matters. And I think yourselves as lawyers, I think you have a term that you use, an ambiguity, something like that. I think that's big English, but nevertheless, I think it's absolutely, you must have absolute clarity so that then we are correctly empowered as a supervisor and a person who's holding institutional responsibility to be able to execute your duty and function. Otherwise, that's my personal opinion on the general, of course, as per the proposition by the chair.
No, I understand you. Let me put this. I think I said yesterday, when I put to the proposition that what do you say about the proposition that the second report may have been or was intended to replace the first one, I don't necessarily mean that if you thought there was something wrong with the first report, or if you thought that arising out of you being given two reports,
right?
The mere fact that the second one is taken as replacing the first one may not necessarily mean that you can't pursue anything that you think needs to be pursued.
Right.
It's simply to say, in this context, it's difficult for me to see how you could have thought that the authors of the report intended you to regard both as valid, as continuing to be their report because they had, for example, recommendations that were in conflict with each other. So once you know that the one report, the later report, has a certain recommendation that is in conflict with a recommendation that was made in the first report, it seems to me that logically you have to say they can't be intending that both must be taken as valid. What you may still say is, okay, I accept that the second one is your final, but there is some concern I have, and that's why I want to look into something. I don't have a problem that you say you regard this second one as final, but that does not remove my concern when I look at what has happened.
Chair, let me try and illustrate this point, maybe differently. And I'll come closer to your profession, okay? So you issue a judgment today, and this judgment is based on certain considerations and the processing up until the point of an order. 3 weeks later, I don't know why I like 3 weeks later. 3 weeks later, the same judge writes the judgment on the same matter, right? Arrives on a different order. But the matter is the same, the material factors are still the same, right? But now what you're confronted with is that right at the tail end of the judgment, you have an order. The first order looks different from the second one. Now, to a person who's the recipient of that order, what is he or she supposed to do? Which order do you then follow, right? Now, And of course, I'm not trying to say that investigation reports are equivalent to judgments and orders. But I'm trying to illustrate this point, that you shall always, as a recipient of either a report and or an order like that, have a problem in terms of which is which then between the two. But you're also likely to ask yourself one logical question flowing from that issue. And that is, how come this order differs from the other? What are the material factors that brought about this? Now, and that's why I said respectfully, I probably disagree with the chair, because the example that you were making is of a general nature. It's any other report like a newspaper article, etc. But now we're talking about institutions of governance, which have got to be, their work must be executed explicitly, boundly, and clear. You know, that's the thing. So I'm not sure what I'm satisfying the chair's.
I think we are very close to
yes.
to seeing the matter in the same way, but I think there's just a little bit of there's a point where we may not be seeing it exactly the same. But
Okay.
let me make this point with regard to a judgment. Judges change their judgments all the time, as long as the judgments have not been handed down.
Right.
Okay. Once they have been handed down, they may correct certain things, not substance. Okay. But before they are handed down, you chop and change. Sometimes 5 days before the date when you are going to hand it down, you are going this way. And 1 day before you hand it down, you realize, no. I'm completely wrong. You go this way. So people don't know how much you agonized and took different twists and turns before ultimately you hand it down. Now, in the case of the investigation report, my understanding is that they presented the second report before you could make any decision on disciplinary matters. They presented the second report before the NPA could make any decisions. You know, so it may be that as long as the powers that we have not made any decisions, it should not be a problem. But if they've already made decisions, it might be a different issue. But I said earlier on, whether you take the report, the second report as as the final one or not, I'm not necessarily saying that if, when you look at what is said in the final report and you look at what is said in the earlier report, you can't pursue an issue that you think should be pursued. So I'm working on the basis that even if you accept that the second report is final, that should not necessarily mean that you can't pursue an issue that is of concern to you, arising from looking at the two reports, but still accepting that the final one is the second one. So that's where I am. I think we are close. We probably, you might not agree, and I might be wrong, but I think we are not as far apart as we might seem.
Okay.
Yeah.
I hear you, Chair.
Yeah, okay, all right.
Thank you, Mr. Chair. Just to be clear about the question of the amendment of reports, etc., I'd asked you whether that was a general proposition or whether you were talking specifically about the amendment of reports in relation to IPID. But I want to ask you a slightly different question, but on the same proposition. Is there anything within government either a statute, a regulation, or standard operating procedure, a manual that stipulates that before you amend a report, or before you produce a second report on the same topic covered by the first report, you must refer to the first report and identify to what extent and why you've changed the first report and why you've done so.
No, let me refer to practice, because I would not recall, of course, the applicable sort of regulations and/or policy positions, but practice has it in government that if you produce a report as contained in what is commonly known as a submission, for an example, and something changes, whether you want to update that, you will need to produce another report in relation to the first submission that you would have made, and point, and refer to it in very direct terms that this report that you're now filing is in relation to submission, whatever code of the submission and the title of the submission, and that you are amending it in respect of whatever the issues are that you would then identify in your new submission. So that's what practice is. And of course, I've not worked for each and every government department, but at least in the areas that I've functioned, I know that that's the case.
And then to follow up on that, is there a rule, a practice, a statute or a regulation which stipulates that if one does not follow this practice of which you speak, that gives rise to misconduct and possibly criminal misconduct?
Chair, that really depends on what each matter would be contained in such a submission for, and the gravity thereof. I mean, really, so.
Well, I'm actually putting it at a very general level. I'm asking you, is there a rule, either a rule that's contained in some instrument, whether it be a statute, a manual, a regulation, which stipulates that the mere failure to follow this practice of which you speak, the mere failure, doesn't matter what the content is, or doesn't matter what the extent is, the mere failure constitutes misconduct or constitutes a criminal offense?
Look, Mr. Hali, it would really depend on the policy framework and outlook of each given government institution, particularly contained in your standard operating procedures. It's possible that another department, depending on what that department would be, it would maybe in the standard operating procedure refer to a misrepresentation of facts or reports or whatever the case is. And therefore, if that is so, that can then be gravitated to an area of misconduct as and when, for instance, an employee would have committed such an alleged sort of offense. So, and that's why I don't want to talk about whether rules, regulations, and or legislation in government, because I mean, really, that's very broad.
Thanks. But of course, the proposition that you advance in and the example that you use of a misrepresentation, that stands on a completely different footing. What you mean there is that when you state one thing, you make it a statement about one thing, whether it's been in a report, whether it's been a verbal statement, when that thing that you know that thing to be false, that would then amount to a misrepresentation. Whether it is a misrepresentation that is actionable in the sense that it is a disciplinary infraction would of course depend on the content of the misrepresentation and its materiality to the workplace. In other words, it's not a matter of, that's a matter relating to your duties.
No, I hear you, Mr. Halley, but I was just making an example in terms of what could also possibly be said in a set of standard operating procedures and/or policy of a particular institution.
I want to deal with a slightly, or move on to a different topic. I mean, you were the Minister of Police. Now, one of the issues that had been raised by Mr. McBride when he came into office sometime in March of 2014 was immediately to identify, once he was told that crime intelligence had been involved in this investigation, he found that particularly strange. And if I understand him correctly, he was saying that it was strange at two levels. It was strange that crime intelligence had been involved in an investigation at all, because crime intelligence doesn't really, to use the language, carry a docket. They don't investigate criminal misconduct. Crime intelligence gathers information, they gather, and they pass it on to some of the other structures within the SAPS. Would that be a fair comment?
Look, I think it is. I think it's also a matter that in the first report of the Civilian Secretariat for Police in 2013, 2012, if I'm not mistaken, does refer to the matter having been picked up by crime intelligence and so on. And I think that's when the minister, before I came in, took a decision to then refer the matter to IPED. But also at the earlier stages, when Ms. Kuki Mpegi was the acting executive director there, there was some involvement of a person from crime intelligence in this. For how long, I don't know, but by at some point, that person withdrew. So the issue of the involvement of crime intelligence did not necessarily arise around about February or March of 2014. I think it's a matter that was there long before the conclusion of the report by Mr. Kuba on the 22nd of January 2014. So, and I think there's something that I must have seen somewhere by Ms. Kukimbegi talking exactly to that issue, a decision being taken, that then crime intelligence needed to be, whomever person was there needed to stand out and away out of the investigative work that IPID was conducting.
But before I deal with that response, I just want to understand, would it be fair to say that crime intelligence is a body or a structure within the SAPS that gathers evidence or gathers information and they pass it on to other bodies or other structures within the SAPS? They don't carry dockets.
Yeah, I think you're correct, with the exception that you corrected yourself there correctly. They don't gather evidence, they gather information.
Yeah. Thanks for that correction. Now, the person you're speaking of is a certain Colonel Mokhangwe, Moukangwe, if my memory serves me correctly.
Right.
Now, in fact, Colonel Mokhangwe didn't withdraw from the matter, as you suggest. He was involved in the matter right up until the matter was being dealt with by Mr. Kuba. And he assisted Mr. Kuba throughout, and he was instructed by Ms. Kukimbeki to have Mr. Kuba or to have Mr. Colonel Mkangwe assisting him at all stages.
Mm-hmm.
Would that be, for you, would that be problematic?
No, look, I think that detail, you know, as and when my understanding is that you could be in the process, Chair, of taking a decision to invite Ms. Mbeki here, because I think she would, you know, be well positioned to clarify that particular point.
Yeah, no, I think that Ms. Mbeki should come and testify. Actually, I was surprised that yesterday, Mr. Halley, you were told that her affidavit is still not final. About a year ago, I said her affidavit should be obtained. But I think the reason why Mr. Halley raises this with you might be the same reason that I wanted to raise some of the issues, including the involvement of Mr. Makwangwe with you. I think he raises it with you because the involvement of crime intelligence or of somebody from, well, the involvement of crime intelligence prior to, in an investigation, because as I understand the position, crime intelligence, excuse me, crime intelligence had conducted some investigation on this rendition issue before the matter was handed over to IPED. And then when it was handed over to IPED, Mr. Mukangwe from crime intelligence, or Mr. Kuba, was told that he was going to conduct the investigation with Mr. Mukangwe. And it appears from Mr. Kuba's affidavit that the justification that was put forward was that because Mr. Mukangwe had done quite a lot of investigation, so he should be kept in the investigation even when the investigation was being conducted by IPED. So my concern is why would crime intelligence, who are not supposed to conduct investigations, one, conduct an investigation in this case, two, remain so interested in this investigation that one of their own must assist or be part of the investigation even when the investigation is under the auspices of IPED. So, Mr. Halley, we will say you might have a different concern, but that's the concern. There are many other fissures, and maybe we'll talk about them, which make one say, but why were things happening the way it suggested were happening in regard to this investigation? Of course, I have not heard everybody. Maybe when I hear witnesses who have not come, who have not been heard yet, like Ms. Mbeki, certain things will begin to make sense. So, but until that happens, there are certain fissures where you say, but why was this happening?
Yes, Chair.
So I think that for me, that's one of the issues to say, you having been Minister of Police, you would be able to say, well, to me, it doesn't look strange that one, crime intelligence conducted investigation on this issue at all, or two, it doesn't, there's nothing strange that somebody from crime intelligence continued to be part of the investigation even when the investigation was done by IPED because of this understanding that I have. Or you might say, it also looks strange to me. So that's what I would like to hear from you, whether what your own reaction is when you hear that this was the case.
No, Honorable Chairperson, I think, in a way, you have also answered yourself, that the operatives, as and when they appear here, from an operational point of view, they will be able to give you further detail, for an example. So it's possible that they will be able to say to you as chair of this commission and say, we had this much amount of information collected. But these were the dynamics and nitty-gritties that also involved that there were certain areas that could only be opened precisely because, they knew us, so it was us who had this information for us to be able to access certain whatever. So, but that's the kind of operational detail that, in my view, as and when the correct people at an operational level are here, and I'm linking to the point that the chair correctly said, and said, look, you have not had everybody, therefore it's likely that as and when we draw in most of these individuals that were involved in this investigation and maybe collection at some point and so on, that matter would be clarified.
But what I would like you to help me with is whether, as somebody who was Minister of Police for a certain period, whether you regard it as normal for crime intelligence, one, to conduct an investigation as opposed to gathering information. I think you made that distinction earlier on. And two, to be part of an investigation that is conducted by IPED. Is there something that would happen in their normal, in the course of their work, as far as you know?
Look, I wouldn't know as far as I know, but I think this question that the Honorable Chair is posing is a relevant question. It's relevant in the sense that it really depends on what the issues were, I suppose. But if you were to ask me at a general level, you are making an inquiry, for an example. I'm just making, this is now a general thing. You're making an inquiry about a certain matter, but who's outside of your function, I happen to be holding a particular information, okay? I think it would make sense that I would have to cooperate with you and say, I hand over this information to you to assist you in your inquiry or investigation that you're making. Now, it's then the question of operational detail of, do I continue to be involved with you for whatever the reasons are, because it really depends on the nature and the weight of that information, I suppose. And to what extent do I continue to assist you in your investigation? And my understanding is that if you look at the historical sort of reports around this issue, crime intelligence is identified as assisting in the investigation, not that they were conducting investigation. So the investigation was conducted by IPED. But for whatever the reasons were, maybe there were operational reasons, whether they were sound or not so sound, I think operatives in that regard would be able to shed some light.
But in terms of the scope of their work, you are not able to say whether this would normally fall within their scope of work.
No, I mean, in terms of the scope of their work, of course, they would not be conducting investigations. They would be collecting information.
Yes.
They would not be investigating police misconduct, for an example.
Yes. Okay, I think that answers my question.
Okay.
I just mentioned, for what it's worth, and you probably can't say anything about it, but it just adds to features that make the involvement of the crime intelligence features that make this investigation strange, or their interest in the matter strange. that according to Mr. Kuba, in his affidavit, one, Miss Mbeki, Kuki Mbeki, told him to keep the involvement of Mr. Mukangwe secret. Two, according to Mr. Kuba, Mr.
Keep the,
Sissoco-
I'm sorry, Chair,
Sorry.
sorry to disturb you. Keep the
Yes.
involvement of Mr. Mukangwe. That's the part, there's a part that I couldn't hear about Mukangwe, yes.
Yes, I'm sorry. I'm saying, according to Mr. Kuba's affidavit, one of the strange things for me is that, according to him, Ms. Kokimbegi told or instructed Mr. Kuba to keep the involvement of Mr. Mukangwe secret in the investigation.
Oh, okay.
Yes, that's one. Two, Mr. Kuba says in his affidavit, Mr. Mukangwe asked him to use certain email addresses when sending him documents about these investigations. But what is strange is that he didn't want Mr. Kuba to send him those documents or emails to his official email address. He gave him a certain email address.
Okay.
It does not, I get the impression from what Kuba says in his affidavit that it might not even have been his personal email address. He insisted that they should not be sent to his official email address. So there are other features that are strange for me, but I'm saying, I'm mentioning these, you probably can't comment on them.
Oh, yeah, no, I hear you, Chair,
Yes.
but there's hardly
Yes.
anything that I can really
can't,
say
yeah.
about that, yeah. No, thank you very much.
Thank you.
Thank you, Mr.
Hali.
Chair. But there's a
sorry, Chair.
further concern.
I'm sorry, I think
Sorry,
Mr.
Chair,
Mukari has something.
before Mr. Hali puts the question, for purposes of arranging my day, I see that we're no longer sticking to the times that were spoken about yesterday.
Yes.
I had to arrange my day in such a manner that I accommodate the proceedings continue today on the basis of what was said.
Yes.
I moved my commitments to the afternoon, 2 o'clock and 4 o'clock.
Yes.
And so if I may be told again that we're going to go on so that I can be able to again then shift my commitments.
No, I'm terribly sorry, Mr. Mukari. Actually, about 11:30, I thought of raising the issue, but I think something happened and I forgot. I did say that we have got to finish within 2 hours, and in 7 minutes' time it will be 2 hours, I think. But it's quite clear we are not done. I also still have got quite some questions. I think as far as today is concerned, everything has been going satisfactorily in terms of everybody has been dealing with matters the way I expected. So there's been cooperation from all sides. Let us talk about what should happen. I know that Mr. Ntlego wanted to get done, and that's why we have moved, and Mr. Mukari also wanted the
I
same.
think all I need to know, Chair, is how much more time so that I'm able to move my commitments.
Yes.
That's all what I need.
Yes, well, let's talk about that. Do we, Mr. Hali, what is your own sense? We have got to
Mr. Chair,
do justice in the end, but we must
Right.
not take too long, but we must still do justice.
obviously, when I formulate an assessment of time, I do so with reference to the questions that I've got
Yeah.
and a response which I think will be accurate according to this. Sometimes if the
Yeah.
response is different, it might take me down
Yeah.
a different pathway.
Yeah.
But speaking generally, I would have thought that 2.5 hours, the assessment of 2.5 hours yesterday would have been a
Yes.
fair assessment.
Yeah,
There's been a few disturbances today, not necessarily related to
yeah,
Mr. Ntleko himself,
Yeah.
but there have been a few disturbances. point I'm making simply is that I think I've still got essentially about three broad issues that I still need to discuss. A lot of it is already dealt with in the affidavit, but I need to get clarity on exactly what has been said with reference to the affidavit.
Yes. Well,
So to answer your question, Mr. Chair, I would have imagined that if everything goes according to the way I formulated it in my head, it would take about an hour and a half at most.
I'm sorry, just repeat that.
What I'm saying is that my assessment, based on the questions that I would ask and the answers that I anticipated getting, I would have assessed that it's around about an hour and a half. But sometimes there's an explanation that
And
accompanies
sometimes
the
the chairperson also has questions.
I didn't say that, Mr. Chair.
Actually, must
I think I can say you are diplomatic.
Actually, when he says an hour and a half, then we must put 30 minutes of the chairperson.
No, that's true.
No, Chair, then that's all what I wanted, just an indication.
Well,
I'm fine.
the reason why I'm taking longer to answer that question on your part is that I realize that this is quite an important thing, and it's quite obvious from Mr. Ntlego's statements over the past 2 days that also he regards this as very important, so it should be dealt with properly. So I've been thinking about whether we shouldn't run away from the idea that we might not finish, so that when he comes back to cross-examine Mr. McBride, we can make space for him to finish first. So that's why I didn't want to immediately answer you. I know that he might have something to say, but Mr. Mukari, do you have something to say, even though he might have something different to say?
Yes, no, I'm saying that my question was only in relation of me then arranging my affairs then for today, not that I was saying that.
That we
so I
should
just want
not,
to know, because I mean, it would be unfair for me to sit here whilst I've arranged with people.
No, that's fine.
So all what I needed was, now that he's
How
given
long?
me the indication.
Yeah.
So during lunchtime, I'm able to then simply then rearrange
Yes.
my affairs. So I'm not saying that we should not continue
not, yeah,
until we
okay.
finish. But I'll prefer that we run and we finish with him.
Yeah.
So that when you come to cross-examine, we cross-examine the McBride.
Yes,
He's going to be
yes.
cross-examined by many people, then this may again then disturb.
Yeah.
And then he has to come from KZN all the time.
Yes. Mr. Ntlego,
So
you
if we
wanted-
can just proceed on that basis.
Yes, Mr. Ntlego, you wanted to say something, you raised your hand.
No. I do confirm this position,
Yes,
that in
yes.
fact we should finish.
Yeah.
But I would have said that perhaps to be on the safe side, we should finish at all costs,
Yeah.
which
we
means that even if it would mean we sit here till 12 midnight,
Yeah.
I would still prefer that we do that, and then we finish.
Yeah.
And then we come back with a dedicated focus on cross-examining Mr. McBride. So that's just my suggestion.
Yeah.
Of course,
Yes.
I'm not a member of the commission.
Yeah.
I'm being subjected to
Yeah.
it, but it's
indicating
a
your
suggestion
preference.
that I'm making.
Yeah.
Yes.
No, that's fine. Well, I think let's continue and we'll talk about how long just now. Because the investigations continue, there can never be a guarantee that you can't be asked to come back if there is a reason. You know,
Yes,
so,
if there is.
But I think the idea is, if we can, let's see if we can try and finish. So I think shall we continue?
Thank you, Mr. Chair.
You talked about 1.5 hours.
I spoke of 1.5 hours based on my assessment.
On your, yeah, but it could be
in my own head.
Let's continue, and shall we say? I don't know if Mr. Noche is here. on the basis that we were going to finish before lunch, there was to be another witness, but I think that that can be sorted out during lunchtime. Let's continue, and at 1 o'clock, let's see whether we take the lunch break at 1 o'clock, maybe a shorter lunch break, or whether we take a full hour, and then maybe, if need be, we continue until maybe 3.
Thank you, Mr. Chair.
Let's see how would that affect your situation, Mr. Mokari? Is that fine?
Chair, all I needed was an indication, then I'll
yeah.
move my things so that we can
Yes.
finish today, yeah.
Okay.
Yes.
Let's say at this stage, we are going to try and finish as early as we can, but at the same time, we want to do justice to the issues, and we are looking at not going beyond 3 o'clock if possible.
Thank you, Mr. Chair.
Okay.
Now, of course, there's an additional problem, and I want to explore this with you, Mr. Nhleko. If I understood the evidence correctly, based on the docket, there were at least the DPCI, which is the Hawks, may have been involved in the investigation sorry, let me rephrase that, may have been implicated in the investigation in respect of the rendition. So there were some Hawks officers that were part of the operation and as one of the different units. Another one was crime intelligence itself. Members of crime intelligence were also part of the investigation, part of the rendition, in the sense that they too had been assisting in the arresting of people. So the proposition I'm putting to you is that it seems to be problematic at least 3 levels. One level is that it seems that crime intelligence is in fact investigating crime intelligence. That's quite apart from the fact that crime intelligence shouldn't be involved in an IPRI investigation.
No, it sounds like you are making an observation. I mean, you are, I suppose, Mr. Hali, within your right to make such an observation. I also still to think that at an operational level, there will be probably clarity around these questions. The involvement of crime intelligence, DPCI, and whatever else and so on. I think people who investigated and other people who played a role in the investigation, should be in a position to clarify the commission around these particular matters.
And my question
But
is,
you are making an observation, and that observation is an observation, sir.
no, of course, but I want to, my observation, of course, is meaningless if there's no evidence to support it. I really want your comment on that. That's my observation, but I would like to know whether you would support that observation as the Minister of Police, that if crime intelligence or members of crime intelligence...
You may be able to say, I think it's a legitimate observation. You may say, I don't think it's well-founded because of A, B, C, D, or you may say, I'm not able to comment.
Look, yes, I may not be able to comment largely because, Chair, I wouldn't know the original reasons why, whether they got involved and to what extent they got involved. So that's why I will not be able to to comment. But if you were to ask me, Mr. Hali, and I'm not suggesting that he should ask me that question. In fact, you are prohibited, Mr. Hali, to ask that question. But the point really being here, whether as a matter of principle, is it correct for an institution to investigate itself? Then I can tell you that it is not correct. And conceptually, that's a different matter altogether as opposed to, yes. So,
Yeah. Well, it's the same point you made yesterday that, well, maybe not the same, but it's related, namely that it wouldn't be right for IPED to report to the National Commissioner because the National Commissioner
Yes.
falls within their jurisdiction of investigation.
Yeah. Is a standing implicated institution.
Thank you, sir. Now, the report, or rather the appointment of worksmen, as understood it from the terms of reference, and of course, please correct me if I'm wrong, but my understanding was that worksmen was supposed to conduct interviews. Is that correct?
Yes, I'm listening. I'm listening, sir.
Well, I'm asking if it's correct. Was it your understanding that you wanted worksmen to conduct interviews?
Look, again, that's operational detail. A Vexman were given a set of terms of reference. Now, operationally, what it means is that as and when they conducted this work, they would then design their work. Okay, I would not design work for them, for an example.
So in other
So
words,
if they-
was your position that they should conduct an investigation? These are the terms of reference. How they went about it was up to them.
Exactly. It's because that's at an operational level. So I suppose, for an example, if you were to say to me, I must investigate a matter which, whatever, I would take your terms of reference and translate them into a work plan and say, this is how I want to go about this, and what kind of a definitive kind of approach, in established kind of standards, for an example, that I would want to follow as an investigator. But I would not then design work for you, in a sense, as an entity that would be investigating. Yes. And maybe just to complete that point, Chair, I'm sorry, Mr. Halley, the terms of reference, who and under which circumstances was the original report altered, and or how the second report came about with both reports signed by the same person, i.e. Mr. Kuba, whether any misconduct or offense has been committed, and if so, by whom. Thirdly, whether there is a prima facie evidence of misconduct and criminal liability by Lieutenant General Dramat, Major General Sbia, and any other officers mentioned in the original report. Fourthly, the circumstances under which report and the docket ended in the NPA, and what happened to the docket whilst in the NPA possession. Lastly, any other matter that might come to your attention during the investigation which is relevant to your conclusions and findings. That's how the terms of reference were framed. But then in the report by Vexman, they then went into the detail in terms of how they went about their investigation. They referred to interviews, recordings, statements, and whatever, and so on, that they collected and so forth. But that was not prescribed by me. I gave them the terms of reference. They then designed their work. Thanks, Chair.
Thank you, Mr.
And
Chair.
thanks, Mr. Halley.
So, as part of the terms of reference, you say in paragraph 6, Mr. Chair, for your benefit, the relevant document is in bundle LEA2. And it's an annexure.
I see that my My bundles have still not been written.
My sincere apologies, Mr. Chair.
This one is bundle LEA.
LEA 2,
That's the one that has got exhibit Y8B.
that's correct, Mr. Chair.
Has somebody given the witness the right bundle?
No, I'm fine. I'm fine. I think I'll follow you. No, I'm saying I'll follow you, but I think I saw it here. It's all right. The bundle, yeah.
So, Mr. Chair, to be specific,
It's just that I no longer have sufficient space here, so
Oh, is that so?
that's why I'm going to use my ear.
Oh, okay.
Yes, so
Well,
it's all right.
you can keep it away if you think you can follow, but
Yes,
as and when you think you need it, indicate.
Yes, I would definitely
okay.
do
No,
that,
that's
yeah.
all right.
So thanks.
That's all right.
thank you, Mr. Chair. The relevant page is at page 638 of that bundle.
What's the page number?
638, Mr. Chair.
638.
That is correct.
Yes.
And in paragraph 6, you say to, as part of your terms of reference, you say to Worksmans that in your investigation, you will interview the relevant witnesses at your own discretion and have access to all relevant documentation, including the 2 reports, the docket, and witness statements made so far. So in short, they were required to interview relevant witnesses at their discretion in order to complete the task that you had placed before them.
Right.
And the task that you had placed before them and to which you wanted an answer was, in the second instance, to determine whether any misconduct or offense had been committed, and if so, by whom. Now, when you talk about an offense, you're referring specifically to a criminal offense.
No, Mr. Halley, offenses, they're also committed at the workplace level. It's an offense not to follow or violate policy, for instance, a workplace policy. So it's not only in relation to
So
criminal.
you meant both a criminal offense and a disciplinary offense?
No, my focus was the question of
A disciplinary?
disciplinary, what the act of misconduct, what
Yeah.
does it then do
Okay.
to the image of the institution?
Okay.
Yes.
And then in paragraph 3, or subparagraph 5.3 rather, you ask whether there is a prima facie evidence of misconduct and criminal liability by Lieutenant General Dramat, Major General Sabir, and any other officers mentioned in the original report. See that?
Yes, I see. Yeah, I hear that, sir.
So, insofar as they were given a mandate to interview relevant witnesses at their discretion, they had to determine whether a prima facie evidence of misconduct, certainly, but also criminal liability existed. And to that extent, they were entitled to interview witnesses. Correct?
That's correct.
Now, to that extent, with respect, Mr. Tleko, they would be conducting a criminal investigation, would they not?
No, I don't think so. I don't think so. You had the Honorable Chair and Mr. Halley. You had a report, January that is, that said these 2 human individuals are implicated in the commission of crime. And then you have another report, the 18th of March, which then exonerated them and pulls them out of this. Now, so we are then investigating, first and foremost, why you have this disjuncture between the two. But also, secondly, that you also need to review available sort of reports, documentation, and whatever else, because it's possible that the second report may be saying, no, we are not liable for a criminal prosecution. I'm just making an example, as recommended. But then, again, Chair, the issue that interestingly you raised yesterday, if you look into the documents that produce the report, and that is the docket, actually, there are statements and reports that implicate these individuals in wrongdoing, right? So that necessarily is not understood as, a legal firm that then is conducting a criminal investigation. So that's a distinction, Mr. Hale.
No, I understand you to be saying that there was information in the dockets, there were statements that were there, and they were certainly entitled to analyze those statements. That's part of their mandate. My earlier question to you, to which I thought I had an affirmative answer, was as far as that is concerned, i.e. clause 5.3, were they also entitled to interview witnesses? I understood your response to be yes. Did I misunderstand you?
I think this point has been canvassed and subsequently sort of responded to.
I'm sorry, I didn't hear that question. What was the question?
So the question, based on the earlier statement, clause 5.3 says, amongst the issues that need to be investigated and to be reported upon as part of the terms of reference was whether there is a prima facie evidence of misconduct and criminal liability by Lieutenant General Dramat, Major General Sabia, and any other officers mentioned in the original report. Part of their terms of reference includes a paragraph 6. It says, in your investigation, you will interview the relevant witnesses at your own discretion and have access to all relevant documentation, including the 2 reports, the docket, and witness statements made so far. So the question that I'd asked Mr. Nhleko earlier was whether in doing so, they would be entitled to actually interview witnesses in relation to clause 5.3. I understood the answer to that to be yes. In other words, in respect of...
Yeah, because he said that how they went about the investigation was their business. You draw attention to paragraph 6, which said they will interview relevant witnesses at their own discretion, which seems to say the same thing, if I'm not mistaken. So it seems to me that he contemplated, and he can speak for himself, my understanding is that he contemplated that if they want to interview witnesses, it was up to them.
Chair,
yeah.
Just to clarify this point, Eddie Father, really. It was critical and important that in the exercise of this work that I conducted and asked Werksman to do, the element of fairness and being just had to be maintained. It had to be there all the time. In other words, it would be unheard of that you're conducting some inquiry of sorts, but eventually you arrive at a conclusion about somebody whom we have not spoken to and find and establish his or her side of the story, for an example. That's I don't know what they call those kinds of investigations really, but it's a biased form of an approach. And therefore, in the framing of the terms of reference, it's vital the question of, yes, this gentleman seated across me here is said to be implicated in this and that, but let me hear him out, and so on. By so doing, you are able to come out with a balanced and an objective product, which is then also is going to assist me as an employer at the time, of course, to be able to act accordingly in following the legal prescripts that govern our country and institutions. Yeah. So I think it should be understood in that sort of context also why that term of reference was included.
But it may be important to understand what the answer you give now does to the earlier answer. The earlier answer having been, I gave them a mandate. How they went about their investigation was their business, okay? But what you have said now seems to emphasize the question of interviewing witnesses on the basis that you say, but it would have been unheard of for them to reach their conclusion without having interviewed persons who may be implicated.
Yes.
So I think that you are saying those two things. Now, of course, you might not say anything to them in your brief to them or mandate to them about interviewing witnesses when your expectation is that they know what they are doing and they will make sure that they conduct the investigation in a manner that meets basic elementary rules of fairness. So you might then say, I'm not going to mention that because it's to be assumed that they will interview them. But you may have a situation where an interview is not necessary, but they send somebody who is implicated an invitation to say, give us your side of the story in writing on this issue and this issue and this issue. So in other words, there might be no interview, but still the person has been given a chance to put their version. So I'm just mentioning because the latest seemed to emphasize that your expectation was that there would be interviews.
No. I'm also, on the one hand, explaining the framework and the outlook, character-wise, of the terms of reference. You see, let's take an example, the first term of reference. It says who and under what circumstances was the original report altered. Now, you are not going to work on the basis of a hearsay to answer this question. All right? It's the same thing, and I think yesterday I made an example about an allegation that says you have stolen a goat. The starting point is that, yes, you have that allegation, but we want me to know, to establish the facts, whether indeed it did happen. So I would come to you and say to you, Ngobese says you stole his goat. Do you know anything about that? Is it true? I'm just making an example. So
what do you say about this allegation?
Exactly, that sort of thing. So, and that approach, I'm arguing further and say that approach satisfies the rules of fairness and being just.
Yeah.
That's all that I say. Thanks.
Thank you, Mr. Chair. I understood from your testimony yesterday that when Worksman's phoned you and said, or contacted you in some way and said that they receive no cooperation, you then telephoned Mr. Kuba and said to him you'd like him to cooperate, or you told him to cooperate. Now, my understanding was, and perhaps I'm wrong, my understanding was that you were directing him or instructing him to cooperate. You were not saying to him, out of fairness, I would like to afford you the opportunity to cooperate.
Yeah, but Mr. Hali, how do you come to that conclusion? Maybe just for the benefit of this exercise, how do you come to the conclusion that your understanding was I was instructing him?
Based on
Maybe start there.
Well, maybe let's put it this way. If you say, I was not instructing him, then you have answered the question. If he has further issues, he has an issue with your answer, he will follow up. If not, it falls away.
Now, Honorable Chair, I understand
Yes.
that also there's a cultural conflict here in a
Yes.
sense.
Yes.
You know, that's a court approach.
Yes,
Okay.
yes, yes.
But for me, understanding that this is an inquiry,
Yeah,
you know, it also becomes useful to understand an informing state of mind behind a particular question and or conclusion. I'm just making an example.
no, I
You know,
understand
because I
that.
don't want to understand Mr. Hali as saying that this is what I said.
Yeah.
You know, so that's a thing. That's why I
maybe
do
let's
this.
do it this way. Mr. Hali, put the basis for your suggestion to him to say this is your suggestion that this was instruction because based on this, and then he can respond.
Thank you, Mr. Chair. When I listened to your testimony yesterday, I understood you had telephoned him in order to instruct him, based on what you had testified, instruct him that he was to cooperate. I might be wrong about that. My recollection may be hazy, but that was certainly my understanding.
You are correct insofar as, yes, I did telephone him. You're correct. You are incorrect insofar as you understood that to mean an instruction. I requested him to cooperate. And that's basically it. Thank you, Chair. And may I also state that the level of mortuariness has improved a little bit. No, it's a little bit better. As to whether it's comfortable, as to the same extent as the chair where he's seated, so that's a different matter altogether.
Well, I can tell you that it's only in my legs that I feel some warmth. On my upper body,
Okay.
I feel quite cold as well.
Right.
Yes, okay, all right, thank you. Yes, Mr. Hali.
Thank you, Mr. Chair.
May I ask this while Mr. Hali is looking for something? In the terms of reference, was there any reason why under 5.3, you don't have to look, I will tell you what it says, why it was necessary to specify the names of Lieutenant General Dramat and Major General Sibia, where you say workmen had to determine whether or investigate whether there is prima facie evidence of misconduct and criminal liability by Lieutenant General Dramat, Major General Sibia, and any other officers mentioned in the original report, as opposed to simply saying that to investigate whether there is prima facie evidence of misconduct and criminal liability by any officers mentioned in the report. Was there a particular reason why the two were specifically mentioned by name?
You know, I suppose it's a explicitity in a sense, because the bone of contention was, the basis of contention here was the question of the two reports and subsequently the recommendations. One set of recommendations with explicitly the names of the individuals that the chair has referred to. The other set of recommendation, this other end of the second, so-called second report, those names having been taken out and so on. So I suppose that's the reason why.
It was the reason, yeah.
Yes, that was the reason why
Yes,
Yes.
yes. I don't know if Mr. Halley covered this, but let me ask. Bearing in mind your evidence that the area where you were to make decisions related to disciplinary matters and not to crime, the NPA would decide matters of crime. Why was it not enough in 5.3 in the terms of reference to say they must investigate whether there was prima facie evidence of misconduct? Because isn't it anything that's a crime would fall under misconduct as well, or would it not?
No, but the point, Chair, is there's no way you will be responsible for a policing portfolio and not be concerned with a situation where your officers are implicated in crime. There's absolutely no way. I think you'll be totally sort of remiss in your responsibility not to be concerned about that. Much as you are not the prosecuting authority, for an example. But, you know, from just your both constitutional and institutional duty, you should be concerned about these, you know. And I think as a matter of fact, I think if remember, it's their workplace, all right? They have got to uphold the law at all material times, follow policy to the letter, and so forth. They have to be the face of the institution, but also they have to be the face of our Constitution and the ultimate outlook of our society, okay? Now, but then you have this allegation that this officer is involved in crime, in the commission of crime, right? So, indeed, that does something to the reputation of the institution, okay? And of course, you will not necessarily prosecute this employee on the basis that you committed ABC, which falls under criminal activity.
But you want to know.
But you want to know, and if that has happened, it's a disrepute to the image of the institution. Yes.
Okay.
Thanks.
Mr. Halley?
Thank you, Mr. Chair. Could I ask you to turn with me to bundle LEA7?
Yeah, go ahead, sir.
Okay, he has got it.
Thank you, Mr. Chair. It's
I'm sorry, what did you say?
it's bundle one, sorry, LEA7, Mr. Chair.
Is it the one marked Y8H?
It is. Sorry, Y8G, pardon me, Mr. Chair. It's Y8G.
LEA?
LEA7, Mr. Chair.
Bundle LEA7, okay.
That is correct. And the specific exhibit is Y8U. It's at page 3,342, Mr. Chair.
3,000?
342.
3342.
That is correct, Mr. Chair. This is an affidavit by Mr. Nhleko. Can I ask you, Mr. Nhleko, if you would turn with me to page 3347 of that document?
What page?
3347, Mr. Chair.
Okay. Okay, just to place on record, that's that's an affidavit by the witness. Dealing with allegations by Mr. Kuba, it starts at 3342. You say we must go to 3347.
That is correct, Mr. Chair.
Yes, continue.
The signature on page 3347, sir, is that your signature?
I seem to have I do have LEA 7, but I'm not following the page. What's,
Right, in the top right-hand corner, page
right.
3347, 3,347.
I was
It's
actually
somewhere
there.
towards the end, if you have got the right
Yeah,
one.
no. I'll get it. 3047. In fact, I think I was there and I saw something else.
My
The very
concern is
last
that you,
page, or the very last
my
document.
concern is that you are at the beginning of the bundle, whereas this page is one of the last ones in the bundle.
3047.
3347, 3,347.
Actually, referring to is,
okay,
are you referring to the affidavit of Friday?
That's right.
Yes, so that's the Friday affidavit.
3347.
3347.
Where did I get the zero from? I thought it was 3047.
It must be Mr. Halley's pronunciation. Mr. Halley.
It's probably my level of educatedness, Chair.
3347.
33.
Yeah.
Yeah, 3347. I've got it.
3347, yeah. Okay.
No, thanks and apologies, Mr. Halley, not to get this thing right.
Is that your signature, sir?
Yes, it is my signature, sir.
And this is an affidavit that you deposed to on the 24th of July of 2020, is that correct?
That's very correct, sir.
I'd like you to turn with me, if you will, to, to page 3345, paragraph 7.
Yes.
You say, I confirm calling Mr. Kuba. This was after I had been made aware by worksmen that he was not cooperating with them. It is clear from the above exchange between the chairperson and Mr. Kuba that the purpose of my call to him was to entrust him to cooperate with worksmen in their investigation. Nothing more and nothing less. So you say that the purpose of the call was to instruct him to cooperate. Is that correct?
It is clear from the above exchange between the chairperson. Who's the chairperson?
The chairperson before you today.
And that paragraph
But
comes
but that
after,
parag-
that paragraph of your affidavit comes after a quotation of Mr. Kuba's evidence from the transcript, I think.
No, but where does it say that I instructed him? Because it's a reference to an exchange between the chairperson of the commission and Mr. Kuba.
Look at the second line of paragraph 7, second sentence. It says, it is clear from the above exchange between the chairperson and Mr. Kuba that the purpose of my call to him was to instruct him to cooperate with workmen's in their investigation, nothing more and nothing less. Says, I find it rather curious that despite Mr. Kuba stating categorically that I did not propose that I meet with him in Cape Town, but that it was my PA that proposed, the chairperson continued to speculate that I wanted Mr. Kuba to come to Cape Town to meet with me. Well, you have not been asked about the second, the last sentence. You have been asked about the one before, but I was reading it just in case there is something there. So I'm not going to say anything about it.
Yeah. No, I don't know if my request was understood as an instruction. Maybe it was. I don't know. But the point is, I asked him to cooperate with the investigation.
But let's get back to page 638.
Well, maybe before you go elsewhere, Mr. Halley, but Mr. Trego, it's not, this sentence doesn't say Mr. Kuba understood what you said to him as an instruction. It's you speaking, saying the purpose, saying it is clear from the above exchange that is between me and Mr. Kuba that the purpose of your call to him was to instruct him to cooperate with workmen. So in other words, what you just said after we looked at the sentence suggested, you were suggesting that if what you said was understood as an instruction, so I'm saying, but you are the one speaking in this sentence, saying it is clear from the exchange between myself and Kuba that the purpose of your call was to instruct him, and you continue to say nothing more, nothing less. So the sentence doesn't say Kuba said he understood that I was instructing him, but actually he's mistaken, I was not instructing him. It's you saying the exchange reveals that the purpose of my call was to instruct him, and nothing more, nothing less.
No, that's fine. I note that point.
You know,
I note
okay,
that
all right.
point, yes.
Okay. Mr. Abby?
Thank you, Mr. Chair. And if you could go back to the terms of reference, which appears in bundle LEA 2, and to page 638 of that bundle.
What page should we go to?
638, Mr. Chair.
600?
638.
638. Yes.
Thank you, Mr. Chair. These are the terms of reference, and I want to just pick up on the distinction that you made with reference to offense. You said you acknowledged that an offense might refer to a criminal offense, but you said your focus was really on misconduct for purposes of disciplinary processes. Is that correct?
Yes, that's correct, sir.
Now, I'm just trying to understand, if you can read that sentence to me again, paragraph 5.2. And then reconsider your answer.
Which says whether there is a prima facie evidence of misconduct.
5.2,
What does it say? How does it start? I'm using it.
whether any
My Yeah. Whether any misconduct or offense has been committed, and if so, by whom?
So what you are suggesting is that that sentence, as you understood it or what you had intended to convey, was whether any misconduct or misconduct has been committed, and if so, by whom? Is that what you're saying?
It says whether any misconduct or offense has been committed, and if so, by whom?
So clearly you're drawing a distinction between misconduct, which is of a disciplinary nature, as between an employer and an employee, and an offense, which is of a criminal nature, which may involve another person, but is a matter for the law enforcement agencies. Would that be fair to say?
No, it's not fair. Because you could also use the term offense as a matter of an emphasis.
Sorry, I don't follow that answer.
I'm saying, Chair, you could use the term offense as a matter of offenses, misconduct and or offense. But it does not suggest that, because once you want to suggest that the usage of the term offense applies only to criminal investigations, I think that's incorrect.
I'll tell you what I expected your answer to be. Based on what you said with regard to 5.3, where you have a reference to misconduct and criminal liability, and based on what you said, why you would nevertheless be interested to know whether a member of the police service had committed a crime. Based on that, I would imagine that when in 5.2 you talk about misconduct and offense, it would fit within that understanding. You want to know if there is misconduct committed by a member of the police service, misconduct which is not a crime, but you are also interested to know if there is a criminal offense that has been committed by a member of the police service. In other words, you are not confining yourself to disciplinary misconduct only. You are also interested in knowing whether a member of the police service has committed a criminal offense. So to me, it seems that that's what I would expect you to say, given the answer you gave earlier on.
Yes. Look, I accept that, Chair. That's also one way of looking at it. But you'd also, earlier on, I made a point, and I said, every workplace is governed by a set of policies and rules and regulations. But also an offense can be committed at a workplace level. For instance, being drunk on duty, it's an offense. Whether it could be criminal or purely an issue of misconduct. So from a broad sort of general understanding point of view, I think also the usage and application of the term offense should not be construed necessarily to mean criminal investigation. So much as the Chair is correct in respect of this particular specific matter, relating to the mere fact that there was a criminal investigation conducted, and one report said this and the other report said that, and so on. So I accept that, but I'm also broadening it out and say, but the usage of the term offense does not necessarily mean that if anybody says, yeah, but it's an offense for you to do this, then that would mean you have committed a crime or something.
I don't think we should spend too much time on it, but I think the reason was simply because when you say misconduct,
Yeah.
that would cover a certain category. When you
Right.
say offense, it might mean whatever is not covered under misconduct might fall under offense, yeah.
Okay.
Thank you, Mr.
No,
Chair.
thanks, Chair.
And of course, what we must bear in mind is that when this matter had been handed over to Worksman's pursuant to these terms of reference that you have outlined here, General Dramat had already been suspended some 2.5 months before that. Is that correct?
Yes, I hear you.
And here you are asking them to investigate the very issue that he already taken a decision on.
And what was my decision, Mr. Halley?
That he should be suspended. Because in your view,
Let me come into this thing, because I think and sometimes I do find the Honorable Chair strange that even lawyers, they miss the point when it comes to this issue of suspension.
Yeah.
In fact, the correct term in the public service context is precautionary suspension. And all it does really, it says, as so and so, there are these allegations that are leveled against you. And we, in other words, as an employer, would like to have an opportunity to investigate these matters further. But in so doing, there should not be an element of interference and or perceived interference. So we are also addressing the issue of perception. So which means there is no decision against you in relation to the alleged violation. It's just for the employer to establish facts around this and then take it on from there, whether or not and whatever. But for some strange reason, many people, including legal practitioners, have begun to understand suspension as a punitive measure when it is not. In fact, suspension also deals with the question of even protecting the same employee. So I'll give you an example. I'm working for the commission, which I truly hope never ever happens. But I'm making an example, Chair, that I work for this commission. But I think there's a Reverend Stemela.
Reverend Stemela.
Yes. He is a co-worker with me. So, but the allegation, it involves our unit, whatever our unit is within the commission, together with Reverend Stemela. Now, and the allegations, it's me who are facing them. If I'm not removed from the workplace for investigation to take place, it is likely that when I come in one day and I have a sour face, and I look at Reverend Stemela could easily turn around and say, hey, the manner in which this gentleman looked at me, I can realize that he's really up in arms against me because he's being investigated and so forth. So it's also about insulating the very same employee not to be subjected to unnecessary negative sort of perceptions, even at a workplace level. But similarly, you also have to protect the institutional process and information as well, amongst other things, so that there's no pollution that takes place there and so on. So that's how it has got to be understood. So I'm raising this point because the manner in which Mr. Halley is raising this issue embraces this negative concept or definition of this concept of suspension, which seem to have taken root out there in society, that if you suspend somebody, it's because that person is guilty of anything. It's not.
Mr. Halley?
Thank you, Mr. Chair. If I can move on.
Well, maybe you, before you move on, let me put this to you, Mr. Nhlego. My understanding is that most, if not all, suspensions, maybe I should stay with most and not go to all. Most suspensions, whether you talk about the private sector or the public sector, suspensions of employees are not based on any finding that has already been made that the employee is guilty. They are effected to allow some form of investigation to take place before a decision is made whether the employee should be charged with misconduct or not.
Yes.
Sometimes they happen at a time when the investigation has taken place, but the hearing, disciplinary hearing, and a decision to charge the employee has been taken. But there's going to be some time before the hearing actually starts and the employee is suspended. The decision whether the employee is guilty or not would be taken by the chairperson of the disciplinary inquiry in due course. So, but nevertheless, there is a general, I think, understanding within the public sector and maybe the private sector, I'm not sure, that before you effect even that suspension, you as the employer would need to be of the prima facie view that there may be something that the employee is guilty of. Because otherwise, if you think there is no basis for this allegation, you wouldn't go that far. That's my understanding of the situation.
No, but if you had to do that, Chair, whilst I agree largely with what we have just said, if you were to assume guilt before investigation, then you're being unfair. So that's why I'm saying in the public service generally, at least wherever I've worked, it's important to emphasize precautionary suspension, because the emphasis on precautionary, all it does is it then says, look, we want to have an opportunity to explore this matter further and so on. And we don't want you to be perceived negatively internally within the institution, nor do we want also to experience as an institution, for instance, a situation where there is interference with the information that we require for purposes of investigation. I'm also aware, because I think the chair has also, broadened this thing and alluded to it. I'm aware also that in other institutions, there is a sentence of suspending somebody without pay for a particular duration.
Which is separate, which is a different thing.
Yes, which is separate, but that's after a disciplinary process would have ensured and so on.
And the point you make is that the suspensions you talk about in the public sector and the suspension we're talking about here in regard to General Dramat was a precautionary, and not a punitive one after a hearing.
Yes.
Okay.
Yes, Chair. Thanks.
Thank you, Mr. Chair. Now,
I say we are at 1 o'clock. Is everybody amenable that we take a shorter lunch break, like 30 minutes?
thank you, Mr. Chair.
Would that be fine? Mr. Nhlego, would that be fine?
Oh, no, I'm more
You'll
than
be
good.
fine.
Yeah, it's
There are
like
two
a Sunday morning.
options. Either we move now up to 1:30 and then we take the lunch break, or we take the lunch break now and come back at 1:30. Is there any particular preference?
Perhaps we should take the lunch break now, Mr. Chair. I would imagine that it would be suitable for Mr. Mukari because I suspect we're going to go into his
Yes.
first appointment.
Okay, let's take the lunch break now then, and then we'll resume at 1:30. Okay, we adjourn.
Thank you.